Hi, everyone. Welcome in. My name is Brandon Laws. I have a retired attorney with me here today to talk about filing lawsuits, and his name is Ralph Pittle. We were just having a discussion yesterday about how there are some Facebook support groups of people that have or that are supporting each other emotionally with tardive dyskinesia and tardive akathisia and other iatrogenic injuries. And it's great that there is emotional support out there. But one of the issues that I've noticed and Ralph is noticing as well is that not many people are filing lawsuits, and people are most likely able to be compensated for very large amounts of money. And in some cases, some of these doctors that are harming people are potentially able to go to prison for the harm that has been done to people. And not only that, there's potential for manufacturers to get sued, pharmacists to be sued, and et cetera. So there are people in these groups that have completely ruined lives that could be financially compensated and receive justice, but are unaware just because the education system in the United States and throughout the world in general, arguably, is just not very well versed. So today, Ralph and I are going to briefly get started to talk to you guys about how you can potentially file a lawsuit, and we'll talk about Ralph's experience as an attorney on how he has successfully won lawsuits and cases he's worked on. And then we'll also briefly discuss, for my subscribers and other people that don't know, what tardive dyskinesia is and tardive akathisia, or also known as just akathisia in general. So Ralph, what we're going to do, like I said, um, yesterday we were talking about how there's these support groups, and that's actually how we met, is in a tardive dyskinesia support group. You were preparing a presentation about a year ago, which is now being worked on, and you did a test run recently. But anyway, you see a lot of people in these groups, and they're getting the emotional support they need, but there's no legal action being taken. And I'd like to, and you as well, would like to make sure that a lot of people are educated more properly to learn that they can file lawsuits. So with that being said, give me like a brief description of, you as an attorney and what your experience has been. Like as an example, we were talking about the 2-year mark and everything like that. So from your viewpoint, what do people need to know to file lawsuits against these doctors? What are they missing, or what can they do to take action?
Well, Brandon, thanks for having me on today, and I appreciate the opportunity to share the information. Um, with regard to tardive dyskinesia or tardive akathisia, what we now know fairly confidently from published literature and announcements by the Food and Drug Administration, there are somewhere in the neighborhood of 500,000 to 600,000 people in the United States today who have tardive dyskinesia, a drug-induced phenomenon which is caused by a large number of antipsychotic drugs or anti-anxiety drugs, but also a small number of gastrointestinal drugs, and in particular, what was known as an acid reflux drug, one called Reglan, Reglan. Well, litigation concerning people with tardive dyskinesia, I learned about somewhere around 1982. At the time, I had just recently completed a law clerk position with the Chief Justice of the Washington State Supreme Court. a position that I came to with a law degree from the American University Washington College of Law in Washington, D.C. But before that, some decades of work in the pharmaceutical industry, um, ultimately leading to a Bachelor of Science in Pharmacy from the University of Michigan College of Pharmacy. My involvement with the pharmaceutical industry began when I was 14 years old. Um, my family lived in South Orange, New Jersey. My grandmother uh, lived in Irvington, New Jersey, 2 bus rides from my junior high, and I got a job at the little family pharmacy where she received her prescription medication. She was a woman in her 80s, and she had a full share of health issues that required quite a few different prescriptions. I started off with the very important and glorious job of tearing up cardboard boxes in the back room. Um, it was a store like any typical pharmacy, many different products, but they also had a liquor license, and they had half of their floor plan with liquor. And so every day, or almost every day, there would be deliveries of large cartons with product to go on the shelves, whether it would be the prescription products or the drugstore sundry products or alcohol products. Every day would bring a large box, and contrary to what we have today with automatic machines that wrap up the used cardboard boxes in binders. In those days, quite a long time ago, I'm 82 years old right now, so I'm talking around 1956, I think.
This is way before iPhone.
Yeah, before iPhones, before the internet. Um, one could say back in the good old days, but actually, life has gotten a lot better for everyone, um, while there's still many problems to solve. In any event, I did that for a couple of years, starting at age 14. And when I was in high school, my high school girlfriend, her father owned a larger pharmacy in East Orange, New Jersey. And it was a single bus ride there after school, and I by that time I was doing a little bit more than ripping up boxes, but at the cash register and dealing with customers. But then in high school, I applied to a couple of different pharmacy schools around the country, and I was accepted at the University of Michigan College of Pharmacy in Ann Arbor, Michigan. So I started there in 1960, um, September of 1960. Um, and I, in the summer of the following summer, um, I went back to my family home in South Orange and spent 2 semesters at Seton Hall University, also located in South Orange, New Jersey, where I repeated one semester of organic chemistry and took the second semester of organic chemistry, and did fairly well that time around. I kind of blew it on my first attempt at organic chemistry. Um, and as I was completing that summer course, I there was a notice posted with the organic chemistry department that Hoffman LaRoche Pharmaceutical, a half an hour drive from South Orange, was looking for a recent student who completed 2 semesters of organic chemistry to work in a research lab um, with an immigrant who was trained at Oxford, Marcel Sondervorst. And that was, I got the job. And Dr. Sondervorst was an inspiring person. He had just created the very first mind active pharmaceutical product ever approved by the FDA. It was an anti anxiety product called Librium, and is still quite widely used today, and many millions of people around the country are using Librium as a tranquilizer.
Well, was that Leo Sternbach that made that? Who was the
Leo, yeah,
Leo?
I said Marcel and I misspoke.
Yeah, so
It was Leo Sternbach, right?
okay, yeah. And if people look up Leo Sternbach, he invented literally hundreds of medications. You can look on New York Times, they have an article on him. So he was heavily involved in pretty much the industry that we have today. If those that are watching, Leo Sternbach is pretty much the reason why we have what we have today regarding pharmaceuticals. And that's something I actually talked to Ralph about, is my concerns with how much did Leo know regarding people getting injured versus not getting injured. But anyway, so Leo Sternbach was involved, and just strange coincidence, Ralph just so happened to be working in the lab, right? You were in the lab with Leo where these medications were first invented then, right?
I was when he hired me. The Librium product had recently been approved by the FDA. Um, and at the time, he was working on modifying the Librium molecule um, and aiming to a product that became eventually patented and sold as Valium. And Valium is widely used today. In fact, it's the number one mind active drug that is used. Um, Neither uh, Librium nor Valium uh, are known for causing um, much harm. They don't cause tardive dyskinesia, as far as I'm aware.
So I'm actually going to stop you there for a moment. I was injured and developed akathisia from Ativan, which might have been one of the medications he invented. And so I developed akathisia and tardive dyskinesia, severe, like arguably one of the worst cases some people have ever witnessed. And I eventually switched to Valium and still have akathisia and tardive dyskinesia with the Valium. So there are some reports of benzodiazepines causing it. And if you look into their effect on GABA and dopamine, it sounds like they can deplete dopamine as well, which I could share resources regarding that. So people could Google um, benzodiazepine akathisia. And there's like, it doesn't show the specifics of Valium and Librium, but it does show other benzos of reports of people developing akathisia from them. And so from what I understand, they all pretty much work in this similar ways. It's just the metabolism is slightly different and the amount of time that they last in the body is slightly different from what I know so far. So there are reports of benzodiazepines causing akathisia, myself being one of them that's developed the condition. And even Dr. Jordan Peterson, which a lot of people know, Dr. Jordan Peterson developed akathisia from taking as prescribed doses of a benzodiazepine. And that's why he disappeared for 1 to 2 years, maybe even longer. And he fled to Russia and was put into a coma to be treated for his akathisia and to get off the medication because he was struggling so badly at the hospitals in Canada and the US to actually get the treatment he needed. And Michaela Peterson, his daughter, there's an emotional video of her getting really upset about how he just needed to get off the meds in his case, and eventually the akathisia went away.
Right, that's what people were asking online, eh? Right. What happened? I took the benzodiazepine the way that it was prescribed, twice a day, 0.25 milligrams. I never really thought about it again. I thought that it was a relatively harmless drug, and I was taking it in a prescribed fashion at not too high a dose, and I started tapering off. Well,
Terrible.
My anxiety levels went higher than anything I'd ever experienced. And I also developed this condition called akathisia. And the best way I can describe that is that it was like being jabbed with something, with a prod, like a cattle prod, something electric or something sharp, nonstop for hours, for all the hours I was awake. It was absolutely, I couldn't sit or lay down or stop moving. And even if I did get up and move, it wasn't like that made it better. I just couldn't stop doing it. It was horrible. Akathisia is horrible. It's like being whipped. That's another way of thinking about it.
I had hundreds, if not thousands of people respond telling me how horrible benzodiazepine withdrawal could be, how they couldn't work, how they were pacing around their backyards for a year. And they basically said, just keep him alive, make sure he stays alive.
The psychiatrists that I spoke with said, when I asked them how long the akathisia was likely to last, they said, well, it could be 2 years. And I thought, no one could live like this for 2 years. It's like, you can't live for 2 years if you're being constantly prodded with something excruciatingly painful on a moment-to-moment basis. It's just not, and there's no escape, there's no relief. That's just not possible. It wasn't possible. The reason I did survive certainly wasn't because I was enjoying my life. The reason is that I had family that I was very attached to and friends who went above and beyond the call of duty, helping to care for me. But the experience was intolerably dreadful.
You were suffering so much that anyone around you suffered.
Yes.
Because of how horrible it was to watch. It was horrible.
All of the negative emotion associated with depression, plus a very high level of anxiety, plus no positive emotion at all, plus the inability to ever relax, even for a moment. And so it was.
Yeah.
I wouldn't recommend it. It's no overstatement to say that for me, the consequence of benzodiazepine withdrawal were worse than death. You don't want to say something like that lightly, but there were lots of times, plenty of times when it would have been preferable, as far as I could tell, just not to be there. In Florida, the best I ever got was not petrified with anxiety, but close to it. And yeah. I had that for a few days in a row, a couple of times. Well, thank you for talking with me.
Well, thanks for being here. It's been a year.
Thanks for your help, too.
Yeah, well, I wasn't going to give up.
So we couldn't get any help in the Western world to get dad off of meds. And like dad's super smart, so he'd get into the office and he'd like, you know, out talk the person, but he wasn't able to stop moving. And he knew it was the drugs too, but going down on them made that worse. It was like, this is bad. It exists on the drug, and going lower makes it worse. I was like, I think they all have to go completely, right? And we tried to go everywhere. I kept calling, you know, hospitals and doctors and being like, okay, this is my dad. He's having like an allergic reaction to the medication he's on, plus mixed with withdrawal. What would you do if we got there? And they'd be like, well, it sounds like bipolar, so we'd adjust his medication. And I was just like, we called 52 places. And I was like, okay. So we went to Russia and they just got rid of the drugs, which was so dangerous and so scary. But he felt way better in like a 6-week period, almost like it was bad. But, you know, he didn't die in an asylum, which was what was going to happen. And now he's like, you know, it took 2019. It took like 3 years for him to like recover from all that. Mm-hmm. And now he's on tour and he's totally fine and he's not taking anything. Amazing. Right? Yeah. But like this stuff, it kills people. Yeah. So that's why. So I started on that, like the Russia topic, because when we went there, they did scans of my dad's brain and they're like, oh, he has brain changes from the antidepressant use. And I was like, what do you mean? Do you know brain changes? That can't be good. They didn't, they're speaking in Russian. I'm like getting information through a translator. Yeah. They're just like, antidepressant caused brain changes. And I was like, no, that's not supposed to happen. Yeah. I was like, is that, because then that would have happened to me. I was like, that's not supposed to happen. It's like, it's long-term high-dose antidepressant use, brain changes. Yeah. Like, oh, brain changes sounds bad. Mm-hmm. But then what happened to dad with akathisia? And then it was so bad. It was every doctor we went to. And it was like him too being like, I'm done. Mm-hmm. I'm done. Like, I'm going to die. I'm done. Yeah. And then I was there being like, no, absolutely not. You're not going to die. Like, this is a drug thing and your brain can heal. But like, whoa, did his brain have to heal? Mm-hmm. Akathisia is a terrifying thing. Mm-hmm. And he doesn't have it anymore. So thank God for that. But I was like, this is like, I'm not going to be able to stop talking about this because this almost killed my dad. And like, it didn't almost kill him. It almost left him to be tortured every day from psych med effects in an asylum. Mm-hmm. That's where it almost left him. It almost left my mom like, oh, it got me. But like, when he was hospitalized for a while, she was like bringing him food every day. I've got like a touch of, just a touch of PTSD from these like experiences. But it was like 2.5 years. Like that could have been my parents' lives. Like my dad in a hospital, actively being tortured from the side effects. My mom bringing him food every day from medications he just needed to be taken off of. Mm-hmm. Mm-hmm. So anyway, so that's why we started to talk about it too. It was like, if there are other people going through this, they just need to know that they have to wait. They just have to get through it and they're going to be okay afterwards.
Mm-hmm. And then to also incorporate, like this needs to be enough up in the zeitgeist that when people are considering starting these drugs, they need to know that this is a possibility, and not in just some like form that's 4 pages long of tiny print and you sign saying, oh yeah, I was informed of the side effects. Like this needs to be a serious conversation with doctors before these medications are started, and especially for God's sake for kids. Like these drugs still, I was on Effexor and Wellbutrin, like, well, they're still not prescribed, they're still not approved for children.
So benzodiazepines have been reported to cause akathisia in a lot of people. Anyway, so so from talking to the Akathisia Alliance for Education and Research, I find it interesting that you so happen to be in the place where the benzodiazepines were invented, although hundreds. The benzos were invented, and I also talked to the Akathisia Alliance on how Reglan metoclopramide, as some people might know it as, also causes akathisia, but not only akathisia, tardive dyskinesia. And so it seems like some of the lawsuits that you've been involved in, or a lot of them, were involved in that medication as well. So anyway, I'll let you get back to what you were saying.
Sure. And so with your comments, it is indeed so that Dr. Sondervorst ultimately created, I think, about 140 some different pharmaceutical products that the Hoffman La Roche company patented and sold. They weren't all mind active drugs. They're what they knew in the kind of testing that's available before a drug gets approved on the market did not reveal any extrapyramidal side effects to the Librium or the Valium, but that is the context of drug injuries and drug product liability litigation. Many people do not realize this, but the FDA itself does not test drugs where drug companies are seeking the privilege of putting a drug on the market. The pharmaceutical industry is an industry intended to make a profit. They develop products where, in order to get approved, they have to show that there are benefits, and they have to show that the benefits outweigh the risks. But then they have to adequately warn physicians so that the physicians in turn can warn their patients about the potential side effects of drugs, any drug, whether it's a mind active drug or any type of drug. The fact that a prescription is necessary means that it's a product that is unavoidably unsafe. A prescription drug product cannot be used over the counter. You can only get it with the prescription of a physician, and that's because there are known and identified risks that could result in serious harm. And the concept of the civil justice system is that it's a organizational system that goes back to the time of the ancient Greeks, Plato, Socrates. Developed and wrote about the concept that all human beings have a duty to use reasonable care to prevent harming another human being. And the common law has developed in the United States, where the judicial system of the United States, created with a three parts of of our system. We have a legislative branch, a judicial branch, and an executive branch. And the judicial branch of the U.S. government, when it comes to civil liability, is based on the concept of negligence. We all have a duty to use reasonable care to avoid harming others if we didn't use reasonable care, and that can be demonstrated to a jury of your peers on a more likely than not basis. One need not establish proof beyond a reasonable doubt. Everyone in the country knows that former President Trump, Mr. Trump, is in a courtroom right now in a criminal trial, and that charge needs to be proved beyond a reasonable doubt with all types of judicial evidentiary requirements and a right to not have to testify against yourself. There are all of the principles of the criminal justice system, but in the civil justice system, there are also many procedural rights to assure that that if you're injured and you bring a claim, you're entitled to a fair jury trial if there's evidence to show that more likely than not you were harmed by the wrongdoing of others. So, if someone goes through a stop sign, that's negligence. Reasonable care tells people that we should stop at stop signs. You go through a stop sign, you run into someone else's vehicle, you cause harm, you were negligent. So if it's more likely than not that you were negligent, that's the burden that is you need to prove, and you don't need to have a unanimous jury. What's needed is it might be 10 people out of a 12-person jury, or 7 people, or 5 people out of a 7-person jury. Or you could, in some jurisdictions, have even only a 3-person jury. But that will change from state to state. But the burden is a preponderance of the evidence rather than proof beyond a reasonable doubt for a majority of the jury, but you don't need a unanimous jury. So coming out of law school, I was had the good fortune of being chosen to law clerk for the Chief Justice of the Washington Supreme Court. And after completing that 1-year clerkship program and passing the bar, only a few years after I was a lawyer, did I have a client come with a healthcare problem, a woman who was rendered infertile and required to have a hysterectomy as a result of her use of what was known as the Dalkon Shield intrauterine device. Now, it turned out that the drug company that brought the Dalkon Shield to market in around 1969, actually, was the A.H. Robbins Company of Richmond, Virginia, and the Dalkon Shield was a defectively designed medical device. Like all intrauterine devices, it was a piece of plastic that was shaped, a thin piece of plastic that was shaped like a shield. And we can have a picture of it in later presentations. And that would be on a plastic inserter stick and an obstetrician gynecologist would push that through a woman's cervix into the uterus, where the inserter stick would be turned, and they would pull the inserter stick down, but the piece of plastic would be left in the uterus, causing a mild irritation of the uterus lining, and that would prevent a fertilized egg from implanting in the uterus. But the concept of the intrauterine device was that a woman could prevent pregnancy until she and a partner were ready to have a child, and there was a tail string attached to that plastic shield that would go through the cervix and hang into the vaginal cavity. But the Dalkon Shield tail string was a multi-filament string with 200 to 400 very tiny, thin fibers wrapped with a nylon sheath. And that left them open so that normal vaginal bacteria, which is normal and appropriate, that every woman has normal vaginal bacteria, but they don't cause infection in the vaginal area. But with the Dalkon Shield, they would wick up through that multi-filament tail string and become deposited in the uterus or in the fallopian tubes or on the woman's ovaries. And then infection would develop, what they call pelvic inflammatory disease. Well, it wasn't too long when there were hundreds, thousands of women developing pelvic inflammatory disease with the Dalkon Shield IUD, and a woman came to my office who had a Dalkon Shield injury, and so I started doing research. What do we know about the Dalkon Shield? And I was fortunate to be at the right place at the right time, because only a short couple of months or so before this client came to me, an attorney in Wichita, Kansas, completed 7 years of discovery and litigation with the A.H. Robbins Company, and eventually uncovered the documents that showed that when they learned of injuries occurring, they literally had all of their Dalkon Shield documents burned. The CEO of the company, E. Claiborne Robbins, ordered his in-house legal department to send a memo to everyone within the company and require everyone to bring all of their documents, anything in their file discussing the Dalkon Shield, and bring them to the attorney, who then instructed his assistant to put them in a furnace and burn them. Fortunately, the in-house attorney kept a stack of some of the most revealing documents in his safe and brought them home. And after many lawsuits around the country, the in-house lawyer was brought into court where he admitted to a group of lawyers up in Minnesota that they had covered up the knowledge they had about the Dalkon Shield.
So the Dalkon Shield was injuring people, and they literally burned the documentation so they wouldn't get caught. Is that?
That is what happened. They literally destroyed evidence, realizing that people were starting to bring lawsuits, and as soon as that happened, they got rid of all of the documents that revealed that they knew that there were infections and that the device was defective because of its multi-filament tail string.
So did they do that out of fear of reputation or financial loss? Was there any discussion of why they did it, or is it they just didn't want to get caught?
Well, I think it's fairly consistent with human nature that wrongdoers do not want to get caught. If you've harmed someone, that ordinarily puts many people into denial. While that's not the right thing to do, the right thing to do, I think that our society decides that if you've made a mistake and you've screwed up and you didn't intentionally cause harm, that you acknowledge that you caused the harm and you compensate the entity or the person, the human that's been harmed, for reasonable compensation depending on the seriousness of the injury. And our judicial system allows a way to get to a conclusion, and the vast majority of civil litigation is settled without going to trial. Once you have all of the facts and you know what the law is, and you know that the burden is more likely than not, then wrongdoers who are shown to have been negligent will settle. But our country has developed an insurance system so that it's mandatory to have insurance if you're driving a vehicle. And indeed, the pharmaceutical industry had insurance to protect their financial interests if a product or a misinformation that they disseminated has caused harm to a human being or property damage to someone. There's an insurance system to pay for it.
Yeah, so I heard from another attorney. He was like involved in one of the first homicide cases from a benzodiazepine. I won't mention the guy's name just for privacy reasons, but he was saying that it's really difficult to sue because of all of these laws that have been set in place. So even if you have a case, people are struggling to file lawsuits, which is really unfortunate. But you've successfully found ways to file lawsuits and have, from what I've heard from you, and have looked up multi-million-dollar settlements that you've really been able to figure out. So even though they're trying to cover up these things, and laws have been set in place against civilians in the U.S., there's still opportunity to file lawsuits and hold people accountable, whether it was negligence by accident, ignorance, or on purpose in some cases maybe, or maybe they burned records. But there's still a way to sue these people, is what I guess I'm getting at. And so you've successfully done that. And with Reglan in particular, it sounds like you actually helped, correct me if I'm wrong, you helped get a black box label warning on Reglan. Is that correct? So you've worked on not only the Dalkon, I believe, but you've also helped with Reglan getting restrictions as well. Is that right?
That is right. And I think the best way of explaining it is to go back to how it came to be that the legal system made it difficult or impossible for people, nearly impossible, obviously not impossible, because I had many clients who were able to get civil cases resolved with manufacturers of Reglan or metoclopramide. The obstacles go back really as a very political event in 1994. So first, of course, to put it into context, if you're dealing with lawsuits against pharmaceutical manufacturers, you're dealing with companies that are bringing in millions and hundreds of millions of dollars. If a drug actually has benefits approved by the FDA, authorized for distribution in the United States, usually that initial authorization is the result of fairly limited testing. You really only need a couple of hundred people in a pre-market test to show that there's a benefit with a risk that's tolerable in light of the benefit.
That's really shocking that it's only like 100 people or so, because thousands, if not millions, of people are taking these drugs.
Right. Yeah. To get the initial FDA approval, a couple of hundred people was adequate for the A.H. Robbins Company to get FDA approval for the Reglan molecule that they purchased the right to distribute from a French company that manufactured the original metoclopramide molecule and distribute that drug in other countries around the world.
And if I remember, I apologize,
yes.
I want to ask
Go
this
ahead.
question. If I remember correctly, during one of your talks, you said there was a company that actually turned down to sell Reglan because they thought it was too dangerous. Is that true?
When the French company that originally brought metoclopramide to market, Delagrange, give me that question one more time.
Yeah, wasn't there a company that actually turned down to help?
Oh yes, okay.
Medication?
When Delagrange knew that it had a product that they were now selling in various countries around the world, they sold it in Ireland, they sold it in Australia, they sold it in France, their own country. They sold it in Israel, they sold it in South America. They had a product that seemed to be reasonably effective for acid reflux, and didn't have any obvious serious side effects. And so, but they, of course, they knew that if they could get it to the U.S., well, now there's a big market. Now they could really make a lot of money. And so they looked for a U.S. company that would be willing to pay for the right to distribute metoclopramide in the United States. And the first company they went to, a very big company that many know of, Merck Sharp and Dohme. Now, Merck Sharp and Dohme had a scientist who studied what was known about metoclopramide, known in other countries around the world where it had now been used for a couple of years, and that scientist reported to the company that it was too dangerous, that the side effects were too serious, and it would not be a worthwhile investment for Merck Sharp and Dohme, particularly if the FDA was going to limit use to relatively short periods of time. If you invest a lot of money, but your patient, you can't sell it for more than a short period of time, then you really can't make money. And it was anticipated that the FDA would put a short-term use on it, because by that point, two other countries, Australia and Ireland, in their FDA type of organization, they had reports coming in from physicians who were using metoclopramide, where patients were developing abnormal involuntary movements known as tardive dyskinesia.
Which we'll get into here in a
So
moment.
the Irish FDA, so to speak, and the Australian FDA sent notice to all physicians about the concern with long-term use of metoclopramide. So when the Robbins company when Merck turned it down, another company then turned down the opportunity to sell in the US. But the A.H. Robbins company, which at the time was making a lot of money from the Dalkon Shield. It was before the evidence came out about the Dalkon Shield harming hundreds of thousands of women around the world, and they were selling the Dalkon Shield to hundreds of thousands of women around the world. And so they were making money, and they were feeling quite proud of themselves. And now they had the opportunity to go into business with a new drug, an oral drug, for a very common condition. Acid reflux is a very, very common condition, particularly as people get older in life, and depending on what their dietary habits are, and those kind of things. Ultimately, it's believed that maybe 1 million people or more ended up with metoclopramide, or Robbins put a brand name on it. They decided to call it Reglan, and that was the first to get FDA approval. And so they had an exclusive period of time when they were the only people permitted to manufacture and distribute Reglan within the United States.
So A.H. Robbins, they not only worked on Dalkon Shield, which injured people, they also then got into using or selling Reglan, which also started injuring people as well. Is that correct?
Right. That is correct. And but what were the obstacles? In 1994, George Bush Jr. Was elected governor of the state of Texas. And his father, of course, preceded him and ran for president. But when Junior got elected, we came to learn eventually that the Heritage Foundation, a group of the most conservative lawyers, were working on a plan to come up with legislation that would protect the pharmaceutical industry. And the documents ultimately show that that they had been working on this plan for a good period of time, months or years. When Bush got elected, on the day following his inaugural address, he called a special session of the Texas legislature, and he spoke to all of the legislators and said that we have a very urgent matter that we need to address immediately. We need to pass a law that would limit what he called the epidemic of lawsuits against frivolous lawsuits against the pharmaceutical community. Lawsuits against the pharmaceutical community, when they are successful, usually involve very serious damages. So if you've caused very serious, life-changing damages, and a jury is convinced that you knew about the problem and you failed to use reasonable care to prevent it from happening, or failed to adequately warn what the risks would be, when the damages are severe, juries find that it takes a lot of money to adequately compensate someone who's been seriously injured.
Which is where
So Bush said to his mostly Republican Texas legislature, we need a bill to prevent that. And he had it all prepared. He said he basically passed it out to them. Here's the bill that I'm proposing that would put an end to these many, many frivolous lawsuits if you pass this bill. And not surprisingly, his Republican legislature passed the bill. And under that bill, if a drug was approved by the Food and Drug Administration, it's presumed to be to have an adequate warning and be reasonably safe. So the fact of FDA approval under this new law created a presumption that the drug is safe and effective. And they passed it that very day. Well, on the next day, the very Republican legislature in Michigan, led by a Republican governor, the governor presented the same bill. It had the same provisions. It was obviously part of some preconceived plan, which I think the evidence shows was put together by the Heritage Foundation. And those are the people, it's Heritage Foundation trained lawyers who are the now majority of the U.S. Supreme Court, that right now is considering whether former President Trump should be immune from accountability, regardless of what he does.
we'll go into that another time.
And that kind of thinking comes from the Heritage Foundation, a very conservative approach to our legal system.
Yeah, for the time being, since you and I have been talking for like 3 hours, we'll go into more depth on those things later. So I think we've got a relatively decent background for now to start. And so I guess from here, maybe we can just briefly talk about, maybe take a break for a couple minutes, and then we'll talk about tardive dyskinesia, not even a couple minutes, just a minute or two, so our brains can reboot.
Okay.
We'll talk about tardive and then what akathisia is as well. And then we'll go into how people should be filing lawsuits. And then, see, I'm getting tired as well. How people should get in the lawsuits. And then you can mention just briefly, maybe like 2 cases you worked on, tardive and then the akathisia suicide case. And then we'll start over from there another day. I think that'll be a good start for us and get this out.
Okay, good.
Okay, surprisingly, it took quite a while just to talk about just a brief discussion of the background of the pharmaceutical industry, and we barely touched on it. We've talked about this stuff for hours, and which we'll talk about more. But from here on out, let's just go over a couple things that can actually help the viewers rather than just talking about things, because we can learn about stuff all day, but if we're not solving and getting justice, like it's not very beneficial. But we did need to look back at the past to see how the system developed into what it is today, so we know how to, navigate it better. And you have so much experience. You probably have more experience than the majority of attorneys today. So it's probably some small things that people can do to probably file that other attorneys might not know, like we kind of talked about with me privately. Anyway, so with that being said, what is tardive dyskinesia, which I could elaborate on. We both know what it is. And then I'll also mention what akathisia is. So from your experience, was tardive your specialty in the latter years, or what was your involvement in tardive dyskinesia, and what is it exactly?
Well, when I finished devoting all of my time to Dalkon Shield litigation, right about at that time, or before it was quite done, I had a woman come to me with tardive dyskinesia, and so I started investigating that, and that became not just my focus, but my entire practice. All of my time that wasn't tied up with wrapping up the Dalkon Shield then turned to Reglan and tardive dyskinesia because, of course, it was the same manufacturer. It was the Robbins company that brought us the Dalkon Shield, and then the Robbins company of Richmond, Virginia, that brought us tardive dyskinesia litigation.
So this stuff basically just kind of fell in your lap almost. It seems like the timeline, it just seems like they just fell together.
Right. Yeah. Once I got started on that, I was somewhat known within the Association of Trial Lawyers of America from the Dalkon Shield work, because that did end up having me joined with Ralph Nader's Public Citizen Litigation Group, and we challenged the plan of reorganization up to the U.S. Supreme Court. But then tardive dyskinesia came along, and actually, even before that, the first person who ever approached me with a tardive dyskinesia claim was a gentleman from New York who was in the film industry. his name was Bob Salant, Salant, and Bob and his brother, and I forget his brother's first name, had the largest number of movie theaters in the country. Nothing compared to current large chains, but they had quite a few movie theaters around the country, and people with movie theaters were people that producers and actors and directors wanted to meet, because when a film company has invested millions of dollars in making a film, now the goal is to get it into theaters for people to see it. And Bob and his brother were the people most well known for doing that. And he also was just a gregarious, delightful, happy type person. Indeed, he moved here to Washington State, Mercer Island, not too far from my Seattle law office, after being roasted at the annual Friars Dinner that's held every year by Catholic Charities in New York. And sometimes they're put on TV, and it's usually well-known actors, directors, producers who end up being roasted by their friends. And Bob Salant was a Catholic Charities roasted person at the Friars Club before he moved to Washington. When he came here, he was somewhat experiencing some manic depressive symptoms, and he went to a local psychiatrist, a well-trained psychiatrist who was on the clinical faculty of the University of Washington School of Psychiatry, and he and Bob Salant was referred there, and Bob's history was taken, and the neurologist put him on Thorazine, a common antipsychotic drug, but we learned afterwards that the psychiatrist had not properly evaluated Bob with an Ames test to evaluate and to get a complete history of any other drugs that might make tardive dyskinesia more likely. And Bob was put on the Thorazine with regular monthly renewals for, as I recall, a couple of years.
So that was that the medication that led to tardive for him? And so what were the symptoms?
And frankly, I can't recall specifically. I could look it up whether he was on Thorazine or Haldol. Either one, those people who are suffering tardive dyskinesia know that those were among the early first phase of antipsychotic medication, and they're among the strongest tardive dyskinesia causes.
Yeah, so I want to mention I was having akathisia and ended up in a psychiatric hospital with akathisia. And so I'm like groaning uncontrollably, and my hands are pacing or whatever my symptoms were or have been back then, and probably still today. And so the nurses decided to give me a Haldol injection. And the next thing I know, like, it was very quick, 30 seconds or less, I bet. It was really fast. They gave me a push IV injection, and my neck goes like this, and my jaw starts locking up. And so I'm literally like stuck like this for an hour in the psychiatric hospital in my room for what was akathisia, which they just completely made worse. And so they thought I was faking it. And I don't know where in the world they would get the idea that some guy could just fake having a face like that. It's absurd and laughable at the same time. And so eventually, after like an hour, they finally come in. They see me sitting there in the chair or whatever, wherever I was sitting, still in that position with my face all locked up and everything. They're like, "Oh, this guy's really messed up." And so they come in and give me some sort of antidote, probably like Benadryl or something. I don't know what it was back then that they used. And so they thought I was faking side effects from these medications that were so severe. My whole face was literally paralyzed and locked up. So Haldol is not a joke. That is a very serious medication that people get injured on, whether that's the one he was injured on or not. And I'll talk to people later about me discovering that I can't metabolize those medications. But anyway, so regardless of what the medication is, we can look it up later in your records or online, I'm assuming. What are the symptoms of tardive dyskinesia that you've witnessed or have worked on? There's a guy, his name is Joey, I think Joey Marino. Unfortunately, he passed away recently. I'll share some video footage of Joey someday of his tardive, which is really severe. Like, there's days when he's unable to leave a facility because his symptoms are so bad. But then other days when he's out in public and he's literally just stuck like this nonstop, and his tongue's moving around and everything else.
Joey,
I can bone.
why are you like this?
Seroquel is said to be the main culprit by my neurologist, which I have tardive dyskinesia, a telephone, dystonia, tardive akathisia, all because of Seroquel, given to me off-label sleep.
This could be your son or your daughter right now. Psychiatry kills. Seroquel and the like, given to people who are not schizophrenic, who are not bipolar, who are not. They give it for sleep. Imagine. Barbaric. God. No. 10-minute office visit. Give me this. I've been fighting and 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 fighting. Oh. How?
So anyway, what have been the symptoms that you've seen and have filed lawsuits for with tardive dyskinesia?
Well, there are kind of two questions that you've come to me with. The symptom that Bob Salant had was that he couldn't stop grinding his teeth.
Okay.
He just couldn't stop grinding his teeth, and over a period of months or multiple months or a year or two, he literally ground his teeth down to the gums.
Ooh.
It just never stopped. But in terms of the symptoms of tardive dyskinesia that I've seen among the 40 or so people whose cases have gone to court where I've represented them, and multiple dozens or hundreds others who never got to court, but because of timing and the legal situation and the financial situation. But the common symptoms that all of your tardive dyskinesia sufferers will know about is the tongue darting and the facial grimacing, the eyelid closing, the Mege syndrome that sufferers will know about. There are a number of different symptoms that clients of mine have experienced, and those 40 or so whose cases were settled, those were people that had lawsuits going, and I needed to meet with them regularly to help them prepare to answer written questions that came from the drug companies or the prescribing doctors. Ordinarily in civil litigation, those are called interrogatories, written questions that you answer under oath. But in the Reglan litigation, where there ultimately were some 25,000 people, lawyers for the brand name companies and multiple generic companies, those people whose cases were coming up, it required spending a lot of time with them in my home, in their home, phone conversations, and I used to have quarterly meetings with some 120 clients, where we would meet for an hour at once every 2 or 3 months, so that I could give them an update on the litigation against the Robbins Company for the tardive dyskinesia injuries. And the law firms that got involved had different perspectives on whether to negotiate a settlement or insist on going to trial. And basically, there were 20 lawyers who were appointed because the Robbins Company went into Chapter 11 bankruptcy once the documents, once it was determined that their lawyer had burned their documents and admitted to it in a court proceeding in front of federal judge Miles Lord up in Minnesota, as I recall. And that brought a lot of new lawsuits to come. Some 20 different law firms got involved. And we broke into two camps. There were those of us, myself, along with a friend and colleague, Fred Bremseth, and Bradley Post, who was the Wichita lawyer who got that very first Reglan litigation lawsuit, which came up with a punitive damage verdict, I think about a $1.7 million verdict, and something around $1 million or so for a compensatory damage. And obviously, that's the kind of thing that would interest lawyers. So various lawyers started advertising for tardive dyskinesia clients.
So with that being said, getting into the lawsuits, we've got people that are injured and most likely are able to be compensated for their injuries but don't know it. So what do they need to know to file a lawsuit? What should they be telling attorneys?
Well, what they need to know is that that they need a lawyer who will file their case in a state court proceeding. We have a federalist system, and under our constitutional republic, it's the states that have the duty to protect safety measures for the people who live in that state. And in federal law, you'd have to have diversity of citizenship in order to be in federal court. And among the things that was detrimental to the litigation is that the lawyers who aim to take control of the litigation, claiming that they had the most experience, filed their cases in federal courts, and under the development of the federal cases, they were facing litigation obstacles where they'd have to prove that the danger that the drug company had been guilty of fraud to overcome the presumption of innocence that the George Bush laws established around the country. After he got Michigan to pass the law, over the next year or so, most every state legislature around the country would adopt these Republican drafted laws that presumed it was an adequate warning and the drug was safe if it was approved by the FDA, unless you could prove fraud.
Okay.
What I was able to do by developing finding expert witnesses who were the leaders in the field, they were able to show that the information disseminated in the package warnings was inaccurate, false, and misleading. I battled them on every issue. I mean, all of the key words in the package insert, or you could read it in the PDR, they would quarrel about what the meaning of that was and how to interpret it.
Oh, we didn't mean it that way. It meant this way. So based on their interpretation. So maybe they did mean it a certain way one day, but maybe during the lawsuits that started happening, oh, we didn't mean it like that. I wouldn't doubt that's happened. Probably.
Yeah, I mean, they continue to insist that they were giving an adequate warning, that they didn't have any obligation to warn the patient. They only had an obligation, they claimed, to put an adequate warning on the label of the bottle that would go to the pharmacy. Well, what does that do for the patient unless when the pharmacy and the pharmacist gets it, and when they've changed the warning, the pharmacist needs to tell the patient. But the medical community in those days was saying that it's not It's not for pharmacists to warn patients. It's for doctors to warn patients. And doctors were prescribing Reglan in what's known as an off-label prescription, because the label said it's indicated for short-term use of up to 12 weeks. But they were saying that you're not obligated, doctors, to limit it to the indicated uses. If you find safe and effective uses over longer periods of time, you're permitted to prescribe it that way, and a pharmacist can't tell you what to do. And so the litigation was claiming if they put the new warning on the bottle that goes to the pharmacy, that's all they had to do. And the pharmacist herself or himself didn't have a duty to give any further warning to the patient.
But that's
and
not
what
true
they
today, right? That's not true today. So, like you sign it when you go to checkout at the pharmacy, you'll sign saying that you either asked a question to the pharmacist or didn't ask, right? So
Yeah.
is that where the lawsuits could start coming in with the pharmacists then? So it's like, I didn't have any questions for the pharmacist, or I did, or I had a conversation with them. I'm assuming that's what that's for.
Well, nowadays, I mean, today, after I think 4 changes that I got initiated, one change at a time with different lawsuits. Now there's an adequate warning on what they're handing out if the patient actually reads it or actually asks the pharmacist to come and tell them about it.
Okay, so if they ask the pharmacist, I'm assuming this is how it works now. If they ask a pharmacist a question about the medication, the pharmacist tells the patient wrong, that's when the lawsuit would be involved with the pharmacy.
That's right.
Okay, that makes sense. So what about, since we've been going for a while, what about filing for a doctor? Let's say somebody gets an injury, like I got injured with akathisia, and negligence was involved, and they developed akathisia or tardive dyskinesia, and the doctor was involved. What should they be telling the attorneys? Or what advice would you give so somebody doesn't get hung up on by an attorney when they're trying to sue, and the attorney says, well, we can't sue Big Pharma, but they're not trying to sue Big Pharma, they're trying to sue the doctors. So what type of like evidence of negligence would be required, or what? Yeah, I guess just that in general, what type of negligence?
Well, because of the work that I did for 40 some years, the idea of not suing Big Pharma because they're too big is actually no longer a problem, because over time I've developed requests for admissions that enable anyone who has tardive dyskinesia to sue everyone involved. You sue the drug company, and you say that the drug company didn't give an adequate warning to the physician. And the drug company claims, well, we now have an adequate warning on the bottle that went to the pharmacy. Well, what did you send to the physician? The answer is they didn't send anything to the physician. But you also would sue the doctor, and for the doctor, you could say, Well, look what's in the warning that's now there. Did you tell your patient when you decided to prescribe the drug? Did you inform the patient that you're prescribing a drug that can and will cause tardive dyskinesia if it's used too long? And it's indicated for only short-term use of 12 weeks. Now, you're permitted legally to prescribe it off-label and prescribe it longer, but under the civil justice system, where you have an obligation to use reasonable care to prevent harming the patient, you have to evaluate the patient. Is that patient suitable for receiving a drug that works in the dopamine system like that?
Okay, so
But let me. I want to go to another point on your own history that you gave.
yeah, sure.
You ended up getting an injection of Haldol.
Yeah, when I was having akathisia. So
And
they
you were
used,
having akathisia. How was the akathisia manifesting itself at that
I
point?
was like, it was really loud groaning and movements from what I could remember. It was a long time ago. I'd have to really think about it. But I'm pretty sure I was doing those really loud groans that I get, vocal groaning at that time. So
All
then they
right.
put me in a room and then injected me with Haldol.
First of all, a push injection is more dangerous than an intravenous drip over 15 minutes. The push injection alone increases the likelihood of developing tardive dyskinesia or tardive dystonia, and it sounds like that's what you had. Immediately after the push, you had tardive dystonia, which turned your head around.
So that's what the clenching thing is? That's called dystonia?
Yeah, that would be tardive, or that would be dystonia, not tardive, because it was immediate. It wasn't late onset. It
Okay.
was dystonia from the push injection. And
Okay, that makes sense. So it's not just Reglan that can cause dystonia or tardive. Excuse me. It's not just Reglan that can cause tardive dystonia from an IV push. It's pretty much other medications like Haldol too then.
all of the neuroleptic medications.
Okay.
In the first generation, Haldol, Thorazine, Mellaril, and others, or the second generation that were theoretically and actually a little bit less likely to cause tardive dyskinesia. But both the first and second generation antipsychotic drugs, properly thought of as neuroleptic drugs, will cause tardive dyskinesia.
Okay. Let's say somebody got injected like I did. I don't know what the voluntary documents are. This is for a different discussion, I guess, for psychiatric admissions. So let's say somebody got injected at the ER, like that guy that had a Taco Bell incident and ended up with the suicide case. So you get an injection and you develop tardive from it. So is it literally as simple as you call an attorney and say, hey, I was at the hospital this day at this time. They gave me Reglan or Haldol or whatever medication, and I developed this symptom, and nobody warned me of symptoms to begin with. I'd like to file a lawsuit. Is that like what they should be saying? Is that it?
Well, yes. I mean, you could just go to any attorney where you live and say that. Then the question is whether the attorney that you've walked into has any experience in working with tardive dyskinesia litigation, and do they have a a roster of experts who have spent the time, had the education and training and experience to go through the documents that the A.H. Robbins Company eventually turned over through discovery, although it took 7 years for me to get them all, and hundreds of thousands of dollars, ultimately resulting in maybe a couple of 100,000 pages from the brand name company, and then similar amounts from each of the generic companies. We had something like 1 million pages of documents, and someone's got to read them and go through them and organize them and find ways to pulling facts together. That took a lot of time, but I now have them, and I have admissions from both generic and brand companies that these are indeed true and accurate copies of the particular group of documents that are important for a jury to see and hear about. So you could go to any lawyer and ask them, but what I'm able to do is help your lawyer wherever she or he is, anywhere in the country, because I can give them the admissions that are only usable in the case where they were admitted, except that I ended up in an agreement where they could be used in any case where I was associated with co-counsel. Now, since I'm no longer currently disabled from actually practicing, nonetheless, if you go to a lawyer, wherever that lawyer might be, and give that lawyer information to contact me, I can show them how they could get the documents that will make it possible to resolve a case within a matter of months, because I have their admissions, under oath in many cases.
Okay, so the best route for people to take then is to ideally find an attorney that has legitimate experience with the condition that they have, in this case, predominantly tardive and akathisia. And so maybe if an attorney doesn't, like I was doing, I reached out to an attorney saying, hey, I was given medications that I shouldn't have been on for akathisia. Would you be willing to consult a attorney from a different state that has experience with akathisia cases and benzodiazepine injuries? So it sounds like the best bet is, number one, find an attorney that has experience in the condition that they have. And worst case scenario number two, find an attorney that is willing to consult with somebody, even if it's out of state, that has the experience necessary to be able to prove that the person was adequately, not adequately educated and was harmed ultimately from the prescriber or the companies involved. So that seems like the best option. So either a tardive attorney or a malpractice attorney in your state with a tardive experienced attorney such as yourself, right?
Well, yes, the challenge is that lawsuits have been turning down tardive dyskinesia litigation because the 25,000 people who, using 40 law firms who sued the brand name and the brand name manufacturers none of those 25,000 people got any money. They were paid something like, I think, $3,000 or $3,500 if they would sign a release that said, I sued you because I claim that your company negligently caused me to have tardive dyskinesia, but you've shown me that I don't have a valid claim, and so I'm going to dismiss the case. I'm going to agree to sign this release that lets you off the hook for any responsibility for my tardive dyskinesia, and you're paying me $3,500, and my lawyer has to agree that it's proper for me to sign that release.
Okay,
So,
and really quick, your camera might need to be adjusted. And it appears like the glory of God is shining on your face like Moses here from
there we go.
The sunset. So you've suddenly turned into Moses, which is actually pretty funny.
Where's the burning bush?
Yeah, where's the bush? I just showed it on YouTube. That's awesome. So I don't know. It's up to you if you want to go a little bit further, or we can follow up a little bit more later.
I'm okay. I mean, it's very late for you, and I know that your Tardive Akathisia is an exhausting ordeal every day. So let's call it good.
Yeah. But
all right. Well, enjoyed talking with you, and have a good rest, and look forward to chatting again.
Thank you so much for helping give us a brief understanding of the industry and the basics of starting a lawsuit and being on my channel, honestly. And it's also an honor to have become your friend over the past almost a year and a half now, I think. So that's been fun. We've had some good conversations, and I've learned a lot. I've learned stuff that I don't think many people will have ever learned in their lifetime, which is because of your experience. So I'm really honored to do that. Just honestly, even outside of learning those things, just becoming your friend is an absolute honor. And so
well, thank you. Good of you to say. I appreciate it. Have a good evening.
Yep, you as well. Talk to you later, Ralph.